So far, throughout our series of lessons on the concept of misrepresentation, what we have been doing is talking about the kinds of things which could represent an actionable misrepresentation, focusing on the idea of statements made of material fact, looking at the idea of whether or not silence could be actionable misrepresentation, and even looking at whether or not an opinion may be actionable misrepresentation. This lesson is going to move on to the third and the final element that relates to actionable misrepresentation, which is the idea of the statement of fact being false that then leads to contractual inducement. It leads to the other party, the aggrieved party, entering into the contract, being induced into the contract. So really, this refers to the fact that for an actionable misrepresentation to be possible, the statement of fact that is false or misleading must induce the other person into entering into a contract. Now, once it has been considered that the statement in question is a statement of material fact and not an opinion and not silence and not a statement of future intent, and now that we have then considered that the statement is false or misrepresented, it is then now up to the statement whether or not, now up to the courts at least, or the parties, to determine that the question of whether or not the other party was induced into the contract on the basis of this misrepresented statement of material fact. And when coming to this conclusion and thinking about this issue, there are generally two considerations which are useful to make the determination on contractual inducement. The first is that the claimant must have knowledge of the statement, and second, that the statement must have contributed materially to the decision by the claimant to enter into the contract. So I'll look at two cases that illustrate this point in a second, but fundamentally, the first point is very easy to understand. If we are trying to make a case for actionable misrepresentation, because of a statement that had been made that was false that induced you into a contract, then in order for that statement to have induced you into a contract, you must have had knowledge of that statement in the first place. If there was no knowledge of the statement, then how could it ever have been contractual inducement? Because you weren't induced by that statement that you didn't have knowledge of. That's the first point. The second point is that the statement must have contributed materially to the decision by the claimant. So not only must it have been a statement that you have had knowledge of, but you must have, on the basis of that statement, made the decision to enter into a contract. Or at the very least, it must have contributed materially to your decision to enter into a contract. Two cases can illustrate this point. The first is the case from 1862 of Horsfall and Thomas. This was a case where a gun was delivered to the defendant. The gun itself had been defective, and as a result of it being defective, it did not work properly. It was argued by the defendant that they would not have purchased the gun if they had known that it was defective. So the question of whether or not it was defective was the question of contractual inducement. The claimant then, of course, sued for the cost of the gun, and the defendant levied this argument on the basis of this. So the argument that it was not working properly, and because it wasn't working properly, they wouldn't have entered into a contract had they known this, and so they refused to pay for the actual gun itself, at which point the claimant, who was the seller of the gun, sued the defendant. This argument would ultimately fail. The claimant could not have induced the defendant into the contract through misrepresentation, since the defendant did not have knowledge of the misrepresentation. Inducement must be on the basis of a statement of fact which was false. The fact that the gun was defective and that this was concealed by the claimant did not induce the defendant into the decision to make the purchase, since the defendant had no knowledge of the defect. They only came to have knowledge of the defect after they had made the purchase. So if they were told, for example, let's say that the gun was working completely fine, and it was working properly, and that there was no problems at all, there was no defective element of the gun at all, and then as a result of making that claim, the defendant then goes into entering a contract saying, well, if it's not defective, I'm going to buy this thing. then this could represent inducement, because then obviously there is a statement of material fact that is made that the claimant did know about, of course, because they were told about it, that turned out to be false. And so this could be actionable misrepresentation. But there was nothing about whether or not the gun worked properly or not in this regard. He just bought it, and then only afterwards did they come to the conclusion that it was not working properly. At which point this did not represent an inducement into the contract, given the fact that they had already been induced into the contract itself. Finally, then, we have the case of Attwood and Small from 1838. This case is quite interesting, albeit a little bit confusing, so I'll take it a little bit slower. The case itself involved the seller of mines and steelworks to the claimant. The defendant would grossly exaggerate the capacity of these properties. The part of difficulty comes when the claimant rely on their own expert independent advisors, who also seem to have supported the exaggerated view that was made by the defendant. When it later came out that the claims were false, the claimant sued on the basis of actionable misrepresentation. Their claim would fail, since it was argued that they didn't actually rely on the statements that were made by the seller, by the vendor, but instead they relied on statements that were made by their own independent expert advisors, who essentially parroted and presented a view that was supportive of the view of the vendor, but still nevertheless it was them that they had the statements from that they then made the contractual inducement for. So this is interesting here. You have you basically, if we strip away all the actual facts and we just talk about the basics, you have a seller who is selling some property, some items, okay, and they are making a basis of the capacity of this property. The buyer goes and gets independent expert advisors to look at the property itself and to come to a conclusion on their own as to whether or not the claims about what this property could do actually was true. Now, the independent expert advisors essentially parroted the views of the sellers. They basically supported the views, and they said, yeah, this is what it will do. And so when it turned out that when they actually made the purchase, and it turned out that the property did not do that, it did not have that capacity, okay, it was not the statement made by the seller that induced the claimant to actually enter into a contract. It was the statement that was made by the independent expert advisors that they brought in. So how could you have made this actionable misrepresentation on the part of the seller? It was technically actionable misrepresentation on the part of the independent expert, but of course the independent expert was not involved in the contract, and so as a result of which you could not have sued the contractor on the basis of misrepresentation, because you didn't get induced into the contract on the basis of their statements, but on the basis of the statements of the independent expert advisors.